in today's session, we're going to be looking at adverse possession, picking up recent cases on factual possession and what that actually means, the need for enclosure or not, the intention to possess and why that's still important and how we demonstrate that as well, and the importance of not having the consent of the paper owner. And I should say at the outset, of course, adverse possession is not adverse. We call it adverse possession because it's the way in which we describe how one person can actually end up owning someone else's, what was originally someone else's land. And that whole concept is known as adverse possession. But as the courts have consistently said, there's nothing adverse about adverse possession. So we'll be looking at what makes adverse possession. There's factual possession, intention to possess, no consent. We'll also be looking as a sort of overview at the transfer of ownership under the Limitation Act 1980 and why that's still important in today's world, and the Land Registration Act 2002, which is to deal with registered land, of course. And we'll be picking up on boundaries and why they're crucial and how you can attempt to locate where the actual boundary runs between two neighbouring pieces of land. It's never an easy task to do, and the land registry doesn't help at all. But we'll look at how the courts would approach that, knowing actually where the boundary between two neighbouring pieces of land actually is. And as Lord Justice Mummery said in the Bradford and James case in the Court of Appeal in 2008, whether you're talking about, what we're talking about really here is a neighbour dispute, because as we'll see, adverse possession increasingly is going to be about neighbouring land. And it's important, therefore, to attempt mediation before things turn nasty and become expensive. The problem with boundary disputes and adverse possession disputes is that, particularly where you're talking about individuals, where you're talking about neighbouring land, the parties will pursue, as the courts have said in one of the cases, pursue this dispute with the zeal of Fortinbras's army. I think this is the Alan Wibberley case, in fact, it comes from, over disputes that are expensive over what is ultimately a small and valueless piece of land, but people's positions become entrenched. And what we need to do is try and unentrench that position. So understanding what adverse possession is and what the sort of evidence is that you need in order to make or refute a claim for adverse possession is going to be important, as is the lack of clarity around where a boundary actually is. And we'll look at the very end at some of the sort of tools that are out there to help you disentangle your clients to make sure that they do make an attempt at mediation before things turn nasty and become very expensive indeed.